And it also gave us a new concept called portability, whereby the exemption of the first spouse is portable to the second spouse, which basically means that a married couple could have $10 million joint, and if they both died before while this law is in effect, there would be no taxes. Because we wouldn't even use the exemption on the first death because there's an unlimited marital deduction. On the second death, that spouse would have a $10 million estate, but they would have their own $5 million exemption plus their spouse's $5 million exemption. But beware, it's only a 2-year fix. If they don't fix it again at the end of 2012, we will be back to the $1 million exemption and the 55% rates. So this is something that people above 1 million need to keep in mind carefully, and your friends who are above that. And also another opportunity this presents, and I won't waste any more time on it, but for folks with large estates, this opportunity to have a gift tax exemption and a GST exemption of $5 million apiece is a tremendous opportunity. You can make some very large tax-free gifts, and then if they change the law later, might be able to avoid the estate tax on them entirely. So wealthy folks need to know about this, and I just wanted to put a slide in there on that. Okay, do we want to talk about Mary? I don't see anybody saying yes or no, so I guess I keep talking. Mary has, she's 70 years old. Ted died last year. She's got a home worth 60, liquid assets of 140 in CDs and an IRA, and she gets $600 a month from Social Security and Ted's pension of $1,000. And she's having some health problems. She had problems with her hip. She's got some dementia problems. Looks like she's going to need some care. She forgets that the stove is on, etc. So these kids are good, but they're not as fast as they need to be sometimes. Just kidding. Okay, so she's probably going to move into an ALF, and it costs $2,600 a month, which is a pretty good deal. And they're going to sell the house. So now they got $200,000, $1,600 income, $1,000 a month negative cash flow. And under that scenario, if nothing changes in the next 16 years, she'll run out of money in 16 years. But it's just extremely unlikely that nothing is going to change. In an assisted living facility, as you require more and more services in the facility, your bill goes up and up to pay for those services. And if she has to go into a nursing home, part of the problem is she's got a lot of assets there that would need to be eaten up before we could get her on nursing home Medicaid. So it's not necessarily a good plan like that. One of the things that might apply there is we might want to do a Medicaid Asset Protection Trust where we put the $200,000 into an IRREV trust so that once we make it through 5 years, that money's no longer available from a Medicaid standpoint. Another thing we might want to think about is if we could have gotten to see that couple before Ted died last year, we could have transferred all the assets to Ted, set up a special needs trust for Mary, and then at Ted's death, the money would go into the SNT, and Mary would be immediately qualified thereafter for government assistance. Another thing we'd want to check is, was Ted a veteran? If Ted was a veteran, we could take steps to try to get a VA benefit for his surviving spouse. More importantly, was Mary a veteran? We might be able to get a veteran's benefit for her, which would be more than a surviving spouse's benefit. So, the point being that, we could get her on the waiting list for diversion, but that would be incompatible with the fact that she has $200,000 of assets. So we'd have to figure out something on that first to get her qualified. And I kind of discussed these other things. Okay, bottom line, avoid self-help. It is a very confusing, constantly changing, interrelated rules and everything. And that's what we're here for, is to try to help you. We talked about avoid misinformation. Avoid feeling helpless. One of the keys here is there are a lot of resources in the community. There is Council on Aging, which has a lot of resources available to folks, and you can just call them and they will help guide you to available resources. There is a toll-free number of an elder helpline if you're having problems and a crisis situation, that you can call them and get directed to resources. One of the boards I'm on is Alzheimer's Community Care, and they have family nurse consultants. You can call them and they'll come out to the house and try to help you. And you know, you can always call us and we'll try to help too. But there are a number of these free services, and just don't feel alone. There's people out there that want to help. And this last little bullet point, avoid crisis planning whenever possible. Yes, that's true. And on our case law, we saw a couple things we could have done in advance before Ted died that could have really made the planning a whole lot easier for us. But don't avoid crisis planning if you're in a crisis. Because one of the things I was trying to illustrate there is, even if you're in a crisis, even if the person's going into the nursing home immediately or they're already in there, we can apply these strategies to get them qualified sooner rather than later. And like Mary, for example, that had the $200,000, we could use what's referred to as a reverse half-a-load strategy. In effect, we could apply for Medicaid, get a penalty started running, make a gift of relatively, well, we make a gift of all the property, pay back half of it to reduce the penalty. The money we pay back, we pay for care during the penalty period. Once the penalty period runs, the other half is in some type of other ownership that's available to help for care, and we accelerated qualification for Medicaid. So one of the keys is that we can do a lot of things. Okay, I am almost done. I wanted to make sure I mentioned a few things. One of the things in your packet is an evaluation form. And we very much appreciate any input that you could give us